Sure. Chaitra, please start.
Yes, sir. A very good morning, my dear students, respected panelists, and faculty members. On behalf of Dayanand Sagar University, I'm Chaitra. Welcome you all for this distinctive webinar. Today's topic is the Bharitya Nyaya Sanhitha, a missed opportunity or a comprehensive legislation. Let me introduce the pillar of our university, who are the brains and key decision makers and inspirational leaders and the backbone of Dayanand Sagar University. Dr. D. Hemachandra Sagar, Chancellor, Dayanand Sagar University. Dr. D. Premachandra Sagar, Pro-Chancellor, Dayanand Sagar University. Dr. Amit R. Bhatt, Vice Chancellor, Dayanand Sagar University. Dr. Putmadapasi, Register, and also Dean for School of Law, Dayanand Sagar University. Let me introduce today's webinar panelist and esteemed speaker who will guide us, enlighten us, and give us constructive views and ideas. I can tell you that it will be a roadmap towards your professional and personal goals. Panelist and speaker, Dr. Bharati S., Professor and Associate Dean, Dayanand Sagar University. She has 30 years of teaching, research, and administrative experience. She is a guide for more than 8 PhD scholars and supervisor for many LLM students' dissertation. Introduced certificate courses on writing research paper in law, introduction to harmful practice and Boolean system, health and hospital laws, supervised national and international collaboration, including Karnataka State Legal Service Authority, Pro Bono Nyaya Bandhu, the Jury Nexa Law Journal, University of Exeter, University of Berkeley, UC Davis School of Law, Columbia University. I welcome Dr. Bharati S. for this webinar.
Thank you, Chaitra. Thank you.
Our next panelist and moderator, Ms. Shivani Datta, Assistant Professor, Dayanand Sagar University. Ms. Shivani Datta is currently pursuing her doctoral studies from National Law School of India University, Bangalore, on the title Bangladeshi Migrants in Assam, Policy Practice and Law. She pursued her BA LLB from MS Ramaya College of Law, Bangalore, and her LLM with the gold medal from National Law University and Judicial Academy, Assam. She has a decade of academic experience and associated with the School of Law, Dayanand Sagar University, Bangalore since 2022. Prior to School of Law, Dayanand Sagar University, she was also associated with the Christ Academy Institute of Law and IFIM Law School, Bangalore. I welcome Ms. Shivani Datta for this webinar.
Thank you.
Sir Manoj Kumar Jina, Assistant Director, Admission Department, Dayanand Sagar University. He is an Assistant Director, Admissions at Dayanand Sagar University, Bangalore, from 6 years associated with Dayanand Sagar University. Leading the team has the cluster head of Karnataka, Maharashtra, and Goa. He has 20 plus years experience in marketing and sales in educational industry. He was also a part of Presidency University, Teachers Group of institutions, Brilliant Tutorials Private Limited, IIHT, and SSL Limited. I welcome Sir Manoj Kumar Jina for this webinar.
Thank you, Chaitra. Thank you.
Today's guest speaker and panelist, Dr. Sandeep Emman, Assistant Professor, National University of Advanced Legal Studies, Kochi. He was awarded PhD for his doctoral thesis He was He was awarded PhD for his doctoral thesis on corporate social accountability in India from NUALS. He has qualified the UGC NET in 2010 and has been awarded JRF in the same year. Before joining NUALS, he had worked with reputed institutions such as NLU Jodhpur, VIT Law School Chennai, SRM Law School Chennai, Reva University Bangalore, and Ramaya College of Law Bangalore. He is an author of 2 books in law and has more than 40 publications to his credit, including journal articles, book chapter, and conference proceedings. He is a recipient of the International Master Scholarship in 2010, offered by the University of Exeter, and was named the International Student Employee of the Year 2011 by the National Association of Student Employee Service UK. I welcome Dr. Sandeep MN for this webinar.
Thanks a lot. Thanks so much.
I request Ms. Shivani Datta to take over this webinar ahead, who is the moderator for this webinar.
Thank you so much, Ms. Chetra, for a very generous introduction of all of us. Before opening the floor for our guest speaker, Dr. Sandeep sir, I would first request Dr. Bharati ma'am to give a glimpse about the School of Law DSU.
Thank you so much, Shivani. Good morning, one and all. It is indeed pleasure to introduce School of Law DSU. A bit about School of Law DSU before I hand over to Dr. Sandeep for the topic what is limelight today. The topic what is to be understood by each one of us. School of Law, the Anand Sagar University, has both 3 years law as well as 5 years law. 5 years law honors we are offering BA LLB as well as BBA LLB. We started our 3 years course in the year 2022 and 5 years course in the year 2023. The school is developing in a massive way, having good number of students, eminent faculties with us, established many centers for development of the school wholeheartedly as well as wholesome development of the students. We have law committees like legal aid cell. We have a debate and literature committee. We have moot court society, which is always the flagship event for any law school. We have trained law professors. We do have visiting professors who come and guide our children on practicing laws, maybe CAPC, CRPC, the new laws, what has been happened today. Dr. Sandeep is going to discuss with us on all those things. And we have committees established for the development of the students across their life as a law student. We encourage students to go for internship every 1 year break during the month of July. One entire month is given for the students to go to law firms for their internship. We have tie-ups with eminent law firms in Bangalore as well as across India. We take up these students' interest. Based upon their interest, we attach them to the law firms where they can hold in their career, they can have the development. And regarding the scholarship, those students who have written their DST examination, there is a scholarship provided for the students. The students who are interested to know about the scholarship, in the end, details regarding the people who are in charge of offering scholarship will also be told each one of you. And this is the law school which is established by the founder who himself, Dayanand Sagar sir, who himself was a barrister. Under his leadership, under his guidance, the law school is established. Hence, we are of the opinion that this law school will definitely take all of you to a greater extent and make you all the very good citizen what is required for the country at this minute. Thank you so much, Shiva. This is a small, short introduction about School of Law, Dayanand Sagar University. Thank you.
Thank you, ma'am. Thank you for a very comprehensive idea about the School of Law. Before proceeding to Dr. Sandeep, sir, do you want to give us a short message to our law aspirants as we see that the law is evolving every day?
Yeah, definitely. law is the only profession, legal fraternity is the only profession which is always required for society. Without law, we are not there. Without law, there is no society. Hence, this is the profession which has many ways of helping society, which can take the students to the next level, which is the backbone for society. So the law aspirants, where you would want to do law, there are many avenues open for all of you. Once you finish your 3 years law or 5 years law, there are so many avenues what will help each one of you for development of your growth. And this is the only profession which is the requirement for the development of society. Hence, I definitely say as well as suggest that each one of you please opt law for your development of the development of you as well as for the benefit of the society. Thank you.
Thank you, ma'am. Thank you so much. Now, without much ado, let's go and look in, have a glimpse about our Bharitya Nyaya Sanhitha, which is the topic for today's discussion, because there are a lot of things to hear from you in a very short span of time. So let's go to Dr. Sandeep, sir, and let's first throw light into the transition from the 1860 to 2024 first from you, sir. Over to you, sir.
Thanks, Shivani. Thank you so much. I hope my voice is coming in through properly. Could you please confirm? All right, excellent. Thank you so much, Dayanand Sagar University, for inviting me here, and obviously, possibly the brain behind this particular seminar, Dr. Bharatya Madam. It was so nice hearing from you after a long time.
Yes, I welcome you, Sandeep, and thank you for accepting my invitation. Thank you so much.
Anytime. Thanks a lot, man. Thank you so much. Thank you so much. Okay, so I think I got to be addressing the gonna be lawyers, the lawyers to be a bit scared about the number of participants that are there. So it's kind of close to 187. Now, I think I have close to 40 minutes, 45 minutes. That's gonna be a bit of a challenge. Exactly like Ms. Shivani ma'am was saying, possibly I'll try to kind of give a glimpse as regards the entire transition from the 1860 to 2024, because the country itself took more than 160 to possibly kind of enact a new one. Somebody attempting to kind of read through the transition in another 40, 45 minutes definitely is going to be a challenge for anybody. So having said that, without kind of wasting much time, I'm intending to share the screen, not to kind of complicate the lecture, to kind of give you the basics regarding whether the transition has been fruitful or not. If somebody can see me, I'm just still attempting to do that. If somebody can confirm whether my screen is visible, it's fine.
Yeah, it's visible, sir.
It's visible. All right. And I hope that I've got a decent network connection as well. In between, it got lost though. So now, see, for the first visible thing that we see when you look at the new IPC from now onwards, the new BNS, the Bharitya Nyaya Sanhitha, is the fact that the word penal has been transformed to Nyaya. So the Indian Penal Code, there's no word penal there. So we're not ideally or supposedly focusing on any sort of punishment. We are possibly focusing on Nyaya, which could possibly be translated to justice. Now, that is something that all the participants should be confirming at least towards the end of the lecture, as regards whether these provisions would achieve in transition from something that was completely focusing on being penal, whether we have achieved that particular transition to only focusing on justice. So I'm not the best person possibly to talk about that, because that is going to be a highly subjective opinion. If you look at the numbers of the provisions, we do not normally teach like that. But then the erstwhile IPC, which had close to 511 sections, now that has been considerably reduced to 358. So that possibly gives an impression that, okay, now the new code is much easier to learn. No, not exactly. There has been a few omissions. There has been a little more additions. What basically happened was, if you look at the earlier IPC, there are different definitions, for dishonestly, fraudulently, gender, everything had separate provisions as such. So section 45 defines something, section 46 defines something. Every set of definitions had a new section number in the earlier IPC. So what happened while we transitioned to the BNS, the Bharitya Nyaya Sanhitha, is that the entire amount of clusters of definitions now is being incorporated into one particular major section, section 2, and all the subclauses of section 2 has these definitions. So that is how a large number of sections, because it was incorporated to one particular major section instead of 2, 3, 4, 5, 6, 7, everything defining individual definitions. Under section 2, we added various subclauses or various clauses which defined or which gave us a lot of definitions. So that is how possibly the number from 511 came down to 358. So that is not something for us to rejoice. Almost the same contents are there left for us to learn. Good things, we'll obviously look at the good sides the first at first, and then possibly lead to a session on the possible confusions that were created by the new BNS. So if you look at the definition for gender, BNS has very cleverly added the term transgender to the definition of gender, which is obviously a progressive step. Now, this would possibly give an answer to the first question that we had, whether did we or are we going to achieve justice or nyaya, whether we have to actually transition from the penal provisions to the justice provisions. Now, when you look at the different forms of punishment, we do have community service also as a form of punishment. So the definition, not the definition, the fact that we have community service as a punishment is reflected under section 4 clause F of BNS. But if you need to know the definition of community service, we need not to look at BNS, we have to look at BNSS, the new CRPC. So where explanation to section 23 of the new CRPC says community service is a form of conviction that is given to a convict, where the convict would be asked to do some kind of a work that is beneficial to the community, for which remuneration will not be paid. No, so that gives a huge impression that yes, so this is one particular point to kind of argue. See, we have achieved some sort of justice where everybody is not being sent behind the bars. We've got some kind of community service being made to be done by a convict, a moral lesson for them, something that is beneficial to the community. But because I mentioned about community service, we do belong to a country which is, or rather, which was kind of infamous, I would say, for giving community service way back somewhere in the 2012s. Way back in 2012 or 13 or 14, we have given community service to an offender who was involved in murdering 6 people, including 3 police officers. So if anybody has heard about the BMW hit and run case, that's so confusing because there are too many in India. I'm talking about the 1999 BMW hit and run case. The offender was a grandson of an arms dealer in the country, so was very much influential. He was very rich. So basically, happened was he kind of thrashed all the barricades, thrashed all the police officers. He also realized the fact that certain police officers were trapped beneath the vehicle. He moved on. He continued with the particular vehicle, and to that sort of a person, the trial got delayed. There's so much to talk about that. We'll talk about all that later if we have time. To that sort of a person, 1999, the offense happened. By around 2012, 2013, 2014, the punishment that the particular person got was community service, because the punishment that was awarded by the court finally was just 2 years of imprisonment and fine. Obviously, some sort of fine doesn't even matter to such rich persons or such influential persons. 2 years of imprisonment, because it already served those 2 years as an under trial prisoner. The only punishment that was given was community service. But fortunately, in our new BNS, only for 6 classified offenses that we give community service as a punishment. So it is up to the Supreme Court or the High Court to kind of tell us whether community service could be given for other offenses or not. But that is kind of slightly a progressive step, is what I would consider. Yes, the new BNS provisions are to a larger extent in consonance with the Supreme Court judgments. So we had one in 2017, September 3rd week, if I'm not wrong, Joseph Shine versus Union of India, which decriminalized the offense of adultery, section 497 IPC. So now we do not see the offense of adultery being there in the new BNS. So we don't have that. So we are kind of in compliance with the Supreme Court judgment that way. the outdated ones. So 310, 311 of IPC, the offense of thug, the punishment for thug, all sorts of things are not there because it's kind of largely covered in other provisions as well. It used to be covered earlier also, but it was there. So it's highly redundant, so that's been excluded. One progressive thing that the new drafters understood, that attempt to commit suicide should not be made a punishable offense. Now, do not get me wrong when I say this. You're so desperate in life that you attempt to commit suicide, which itself is a very regressive step. So I want everybody not to do that. Give it some time. Life has some other, messages also for you, good ones, not always bad ones. It's just a matter of waiting for some more time that the bad things come to an end, the good things started to start. So it's to start to occur. So attempt to commit suicide, what basically happened was, we had a lot of judgments. I'm not trying to kind of scare all the attendees with the judgments, but there was one interesting factor. So the court, by way of a lot of judgments, Gian, a lot of judgments said, right to life is not a right that is granted by you to yourself. It's just that it so happened to you. So right to life is a natural right. It is inherent in you. You did not give you right to life, so you cannot take away that particular right. So right to die essentially is not a right. And even if we say that I don't want right to life because right to life is a fundamental right, I can waive that particular right. Waiver is not applicable to fundamental rights in the Indian context, barring some exceptions. Right to life is there for you as well as for me. Right to life is there for everybody. It is for the community. So you cannot solely decide whether you want to take away that particular right to life, is what the Supreme Court said. I am talking about a 2 to 3 days lecture in like 2 minutes. So excuse that particular part. So I hope you understood. Attempt to commit suicide was a punishable offense. You're so desperate that you try to commit suicide, you miserably fail in that as well, right? So what does the law do to you? 1 year imprisonment and possibly fine. That's too much. That's too much. 2017, when the Mental Health Care Act came up, Section 115 says, notwithstanding anything contained in any other law, meaning what? Irrespective of what IPC says, irrespective of what any other law says, attempt to commit suicide means those persons are undergoing severe stress, that they cannot be imprisoned or punished, they require treatment. But then matters went up to the Supreme Court. How can a Mental Health Care Act override the effects of IPC was a question. But luckily now, at least people now have understood that attempt to commit suicide is because of stress. You miserably fail in that particular attempt. You need not be imprisoned. You shall not be imprisoned. You require treatment. Possibly you require support, you require counseling. Thank God we have understood that now. But the attempt to commit suicide has been retained in one of the provisions, which is section 226 of the new BNS. Say, for example, you cannot compel a public servant to do a duty, you cannot compel a public servant not to do a duty by attempting to commit suicide. That gets punishable. That's all. I'm going to be very quick in my session.
Sir,
Some of the out
so just to,
yes,
sorry to interrupt, before going to the
sorry.
next slide, could I request you to please put it in the slideshow mode, the PPT?
Oh, it's not moving to the other one.
Yeah, like slideshow mode, it is difficult for them to see it since.
Okay, what about now, ma'am? Is it better?
No, just put it in the slideshow mode. It will.
I did. I did.
I think now it must be visible.
Yep.
Okay.
I did. I just did that.
Okay.
Okay.
Yeah.
All right. Can I continue, ma'am?
Yeah, please go ahead.
All right. All right. Now, but please let me know when the time is up as well. And I'm not going into too much of details as well because of the shortage of time.
Yeah,
Now,
sure.
see, there's a certain outdated terms that got removed. Say, for example, there was at one particular point of time, we had something called as a jury trial. Persons, for quickly understanding what jury trial is, please join the university, wait till the third semester. If it is really, really, really important, please watch a movie by name A Few Good Men, right? Starring Tom Cruise, you'll understand what a jury trial is all about. Now, such phrases have been removed. So you do not find the phrase juror anymore in BNS because that's kind of outdated. We do not have juries deciding, convictions or acquittals anymore. There are a lot of confusions associated with gang rape often. Say, for example, gang rape of a woman, this was a punishment. Gang rape of a woman less than 16, another set of punishment. Gang rape of a woman less than 12, another set of punishment. Now we just have two gradations of gang rape. Gang rape of a woman, gang rape of a woman below 18. So such confusions were kind of resolved in the new BNS. We have incorporated new offenses. We have incorporated many actually. We have incorporated organized crimes. We have incorporated petty organized crimes as an offense. We have incorporated terrorist act as an offense. We have also incorporated mob lynching. Per se, not exactly mob lynching, because mob lynching is not the word that the Sanhita uses, but different resources say we do have one of the clauses under punishment for murder that would punish something equivalent to that of mob lynching, because that's been a problematic situation in this particular country. Now, there are more offenses for which punishment has been prescribed for life imprisonment, with a specific rider being life imprisonment till the remainder of the natural life of the convict in prison, meaning the particular person has to die inside the jail. Earlier, life imprisonment used to be remitted, used to be used to be commuted to something lesser. Now the problem is there is the option of remission. So far as the state government is concerned, may not be there. May not be there. You'll understand. Attendees will understand largely about this thing when you join a law school. There are very interesting case laws in the name of Swami Shraddhananda. Motivating or persuading a married woman to get divorced only for the purpose of marrying that particular lady and then appropriating all of her wealth and killing her while she was asleep by giving too much and too much of sleeping pills and burying her in her own house, where the police officers, the investigating officers had a really tough time identifying where the body has been disposed of. That was one of the cases where the Supreme Court said, now we are giving life imprisonment, not just any other sort of life imprisonment that we are giving. We are commuting death penalty to life imprisonment, but we are ensuring the fact that the convict would remain in prison till the end of the life. Then the question came: can the state government remit that particular? Can they reduce that life imprisonment as such? So you'll understand that in detail when you deal with Rajiv Gandhi assassination case, Reharan versus Union of India. Now life imprisonment, many provisions, rape, acid attack, many provisions in BNS have this clarity: life imprisonment till the remainder of natural life in prison. Other provisions might say just life imprisonment, meaning there could be possible reduction in the life imprisonment sentence also. Increased punishments of for us various offenses. Say, for example, criminal misappropriation. We have introduced a minimum punishment of 6 months that wasn't there before. Earlier, there was an option either imprisonment or fine. Now, fine is something that is mandatory, it is not optional. If you look at another offense, criminal breach of trust, earlier the punishment was just 3 years. Now that has been increased to 5 years. Cheating, section 318, punishment was 3 years before, now it is 5 years. Cheating by personation, 3 to 5. There are lots and lots and lots of provisions. Say, for example, wrongful restraint, wrongful confinement. You see punishments being increased. And now comes the question which I asked earlier. I'm not giving a solid answer here. If you are focusing not on penal provisions, we are not focusing primarily on the punishment provisions, why are you increasing the punishments now? Is that the way the new code is looking at giving justice to victims? So, for example, you are booking the offenders for more and more and more punishment. Is that the way you're trying to bring in justice to the victims, or are we continuing with the outdated form of a deterrence form of punishment? We are giving them so much and so much of punishments that would possibly deter the future offenders from committing crimes. Now,
So
this is
exactly,
interesting.
sir. This, with respect to this, like my question to you is that, do you think that it has moved from a reformative theory to a more deterrent theory, or what is your perspective on this? That will it serve our purpose?
Okay, now I'm not really sure as to whether that's going to be a bit too tough for the listeners, given the fact that they haven't joined law school yet. But then, yes, so you do have, ma'am, like you said, you do have various forms of or various modes of punishment. Now, ultimately, at the end of the day, be it reformative, be it preventive, be it deterrence, the problem is we never would obviously prefer a particular code or a particular piece of law or a legislation that would be only focusing on punishment. So I believe that way BNS has kind of created a particular balance. Say, for example, leaving out some of the outdated provisions, some of the phrases, taking away some of the punishments that were given earlier. Like I was saying, bringing in community service as a punishment itself is a strong message towards some kind of a reformative set of punishments. There are drawbacks as well. Say, for example, you're bringing in community service anyway. There are certain offenses such as keeping lottery offices, illegally. Why can't we actually give community services for those offenses also? So we have missed out on certain things, but we have been, or rather we have tried to kind of bring in some progressive steps towards a reformative sets of punishments also. Now there is no proof for saying that criminal misappropriation, cheating, criminal wrongful restraint, wrongful confinements were on the increase, or that particular sort of punishment, be it 1 year or 2 years or 3 years, were so insufficient because of which we are increasing the punishment. That particular proof, that particular statistical data has not been released anywhere, because of which we may also come to the conclusion that this transition has been a bit regressive, because again we are going back to the outdated concept, or rather one particular concept that we are trying to get it, trying to get avoided, the preventive or the deterrent effect as such. Now that you've asked this particular question, we have given death penalty for a few more offenses as well. Now the problem is that the students who are willing to join law, please do focus on two different instances. After this particular lecture, if my lecture is too boring even now itself, you may just give these keywords, two keywords in Google. So Google this name, Carlos D. Luna, Carlos. Next word is DE. The third word is LUNA. Carlos D. Luna, death penalty by Texas, state of Texas in the United States. I hope you all got it. Carlos D. Luna, death penalty by Texas. Second one is Derek Bentley, DEREK BENTLEY. Two words. So now ma'am is there. I possibly would ask this particular question back to ma'am itself. Say, for example, ma'am, let him have it. Ma'am, what could be the meaning? I'm so sorry for asking this very silly question. Let him have it. What could be the possible meaning of this, ma'am? Let him have it. I cannot see you right now because I can only see my slide. I hope you're still there. Let him have it. What could be the meaning in English? The meaning would be that whatever is there with you could be given to him, right? Correct. Yes. Now, if you are holding a pistol at a police officer, and we both are attempting to commit a crime which was intercepted by the police officer, so you are holding a gun or a pistol right at the police officer's forehead, and the police officer asks you to give back the pistol. You look at me and I tell you, let him have it. What all could be the possible meanings? Either to give back the gun or to fire the shot at him. Let him have it, to fire the shot, right? This possible confusions could be there. Now, this happened in Derek Bentley's case. I'm not elaborating that too much. This happened in Derek Bentley's case. This Derek Bentley was killed by law, or death penalty was provided because it seems that he instigated a particular juvenile. He used the words to a juvenile who was his accomplice. Let him have it. The juvenile the juvenile fired the shot. The police officer died. Juvenile was only given 3 years because that is the law. Derek Bentley was given death penalty in the 1950s. 45 years later, the British government as well as the judiciary gave him posthumous pardon after he was dead, 45 years ago. So such things have happened. Carlos D. Luna, that was a death penalty given by Texas in US based on a mistaken identity. Carlos Hernandez was the culprit. Instant, a poor person, an innocent civilian, Carlos D. Luna was murdered. Interesting factors. Death penalty. Why are we retaining death penalty? See, I'm not against that per se because of very subjective reasons of mine, but you have death penalty also in most of the cases. So I cannot say it's a huge reformative step. I hope at least the listeners got a bit of clarity in the answer that I gave. It's not hugely reformative, but bits and pieces here and there, yes, I might have to say it's also reformative as well. Is that okay, ma'am?
Yeah. Please go ahead.
All right, excellent. Now, this is one particular provision that was in the debate for a long period of time, Section 104. See, somebody who is facing life imprisonment, okay, he escapes custody and he commits murder, right? Now, the only punishment that was given was death penalty then. So, if I am undergoing life imprisonment, I commit another murder by escaping custody. The only punishment that was given by IPC was death penalty. Now, the problem is, you look at the entire scheme of IPC, barring this particular provision, 303, it's not there anymore in the IPC. So, you see, every time the provisions would say up to 10 years, up to 5 years, up to 2 years, life imprisonment or death penalty or fine or both, right? Up to 7 years or life imprisonment or fine or both. So that gives the option to the judges to give punishments in a different way to different offenders, because offenders will not be the same, crime will not be the same, because at least the victims would be different. So no crimes could be the same, could be identical in almost all cases. Some amount of differences between there with regard to the pattern in which crimes are committed, with regard to the manner in which the crime is committed, with regard to the weapons being used, without the date, the cause of action, whatever that is, things could be different. Not two cases may be identical. So we call this as individualization of punishment, large amount of judicial discretion being given to kind of give punishment that favors a particular crime or the accused or the victim. That was not there. But that particular provision has been revived by giving an option here. Somebody is undergoing life imprisonment, he escapes custody, he commits murder, he may be punished with death or imprisonment for life. So that particular option has been given right now. So it was one particular case, Mittu versus State of Punjab, that read that particular provision which was not giving an option as unconstitutional. But now this particular option has been given. Now let's come to another one. Earlier 304A, which is rather section 106, causing death by negligence. All the listeners would have obviously listened to a very famous Bollywood actor taking his car through the footpaths and murdering somebody. Very honestly, I forgot the person's name also. Okay, right. Now, causing death by negligence. Earlier it was 2 years. Now it has been increased to 5 years. One couple of interesting things here. I'll try to be very quick as well. See, there was this one particular justification that was given to doctors. There's so much talk about this. I'm not doing that. One exception, which that was whenever doctors were negligent, doctors are not given any sort of imprisonment. Have you read in the newspapers anywhere where the highest court of a country, right, or the high court at least, have given imprisonment to a doctor for negligence cases, for cases of medical negligence? You don't. Trial courts, yes, overruled or overturned by the high courts and the Supreme Courts. You only give exemplary compensation. So medical professionals were given a free run. The reasons that the courts have said, Suresh Gupta's case, Jacob Matthews' case, that the courts have said, if you say that doctors also might have to face criminal liability, imprisonment, their hands will shiver when they perform surgery. Or in emergency medical cases, they will say, no, I will not touch this particular patient because if at all it goes wrong, I'll be imprisoned. I don't want that to happen. So I'll better say no. So in order to avoid such cases, medical practitioners were brought under liability. If at all there are any questions regarding this and towards then, I'll be happy to clarify, but not now. But now medical practitioners are also given an imprisonment which may extend up to 2 years. Now look at this interesting factor, clause 2. Whoever causes death of any person by rash and negligent driving and escapes without reporting it to a police officer or a magistrate. So if you hit a particular person, if he's injured, you will get only maximum 5 years. If you cause the death of a particular person, but you get out of the vehicle, understands the fact that the particular person is dead, you inform that to the police officer or a magistrate, still you will get only 5 years. Imagine the fact that you hit a particular person, he dies, you proceed with the journey, you don't inform a police officer or a magistrate, then you will
So,
get 10 years.
so
Yes.
again, sorry to interrupt. Can you please change the slide? It's still in the second slide, I think.
Which starts with?
Sir, Dr. Sandeep, sir, I request you to kindly change the slide.
Yeah, where is it now? In which particular slide?
It's still in the second slide, I think. So it's in the
Oh,
good
that's
side.
so-
The good.
Sir, you can.
Isn't the slide?
Yeah. Also, I request the participants to kindly fill the form which is shared with them, and the question and answers we will take up towards the end of the session. Thank you.
Is this slide talking about a murder by life convict now?
No,
I've
sir.
stopped the slideshow now.
It's
That's problem.
no. It's murder by life convict. Yes, 104.
Yes. Okay. Right, even now as well? Now
Yes.
I've just switched on the slide sharing mode. Yes.
Yes.
So clause 2 of 106, causing death by negligence, is what I was talking to you about. So you hit a particular person, he dies, right? That doesn't mean that you'll be given 10 years. If you fail to inform a police officer or a magistrate soon after the incident of the fact that you hit a particular person and then he died, then only you will get 10 years. Otherwise, still it is 5 years. Now, the interesting factor here is there is one particular concept in law. The word could be a bit complicated. It is called as protection against self-incrimination. Say, for example, if I have done a crime, law doesn't expect me to confess the fact that I've done the crime. Did you understand? I hope all of you understood. So that's called a self-incrimination. No person shall be compelled to be a witness against himself. Here, what happens is you are the driver, You hit a particular person, you causes death. What is that the law asks you to do? You have to report the fact that you have committed a crime to a police officer or a magistrate. Otherwise, it is an increase of 5 years imprisonment. You will get maximum 10 years, 5 for the offense of causing death by negligence, 5 for not reporting it to a police officer, which could be a huge challenge. Okay. Now I've shifted on to the next slide, with the title is confusion, which starts with trafficking of a person. Can you all see that? Or is it still in the earlier slide?
It's still in the earlier slide, sir.
Okay, so I'll minimize that. I'll change the new one
Now,
and then
yeah,
I'll put the slide
yeah,
show
it's
on.
visible now.
Right, right. Yes. So when you talk about, see, I did mention the fact that because of one particular judgment, the option that was not given to the judges, right, the judicial discretion when it comes to awarding punishments, that was rectified. Right, whoever is in custody, whoever is facing life imprisonment, if he commits murder again, now we have life imprisonment or death as a punishment. Earlier, only one sort of punishment was there, which was against the law, individualization of punishment. If see that was cured on one part. Now look at this particular punishment given to trafficking of a person. If a particular person has been convicted for the offense of trafficking of a child multiple times, more than once, such person shall be imprisonment, such person shall be given imprisonment for life. That is the only punishment that this particular provision talks about. Where are the options here? There is no other option. 10 years, 12 years, life imprisonment, death penalty. Nothing is there. Only one punishment. So if there is a particular person who has been caught and punished for trafficking of a child, repeat offender, if he has done that particular offense again, then the only option so far as the law is concerned is give one particular punishment, which is imprisonment for life. Now this is a problem. This is inadvertent. This is a careless mistake that's been committed. You want to comply with Mithu versus State of Punjab, you did that in one particular provision. What about other provisions? That is a problem. Now 358.3, this could be a little confusing, so I think I'll just avoid this particular part. It's about ex post facto laws and all that. If there are questions on this, possibly I'll take them. Otherwise, I think it's a bit complicated to kind of say at this particular stage. Now let's move on to the other provisions as such. I think I'll have to finish in the next 10 minutes. You have new offenses being incorporated into the BNS. There's absolutely no doubt. Say for example, one is organized crimes. See, there were state-specific legislations in India regarding organized crimes. We used to call it MACOCA, Maharashtra Control of Organized Crimes Act, Gujarat Control of Organized Crimes Act, Karnataka also have that legislation. Kerala doesn't have that legislation. Kerala tried to bring in that particular legislation. Kerala has only something called as CAPA instead of Kerala Control of Organized Crimes Act. Now, the very peripherally, I'll just tell you this thing. If you look at the offenses, if you look at the punishments that are there in Maharashtra, Gujarat, Karnataka, state-specific organized crime legislations, and if you compare that with the BNS organized crime provision, there are lots and lots of disparities, which is a problem. Because organized crimes uses land grabbing, cyber crimes. Cyber crime is not even a word that you will find in Information Technology Act. It is cyber contraventions that are there, not cyber crimes per se. So there are lots of disparities that we see. Maharashtra one uses the term promoting insurgency. Gujarat uses the term running large-scale gambling rackets. These are not the things that you will find in Section 111 BNS, which talks about organized crimes. Punishments also, huge amount of differences are there when it comes to punishments as well. So how to resolve this thing could be a huge challenge. Could be a massive challenge.
So,
State-specific
so sir,
legislation says something else.
so sir,
Yes,
you
please.
think that there is a conflict between other statutes which we have with respect to the BNS?
Absolutely. Thank you so much for asking that question, because that would enable me to kind of say 2, 3 slides in one go. One is with regard to organized crimes. You have state-specific legislations. Ma'am, there are conflicts between the state-specific legislations itself. Say, for example, I'm pretty much sure that all of us are aware of the fact that we have one particular legislation to counter terrorism in India, which is the UAPA. So we don't have TADA anymore, we don't have POTA anymore, we only have UAPA, right? Unlawful Activities Prevention Act, Section 15 defines what a terrorist act is, which means that it is the center which takes care of counter-terrorism measures. The state police officers can investigate, but the moment they'll understand it is a terrorist offense that they're investigating, be it the state police officers or the ATS, anti-terrorism squad, immediately they have to give that particular file to the NIA Act, in a national investigation agency act specifically says that investigation may be started by the state, but immediately it has to go to the NIA. Now the problem is Gujarat Control of Organized Crimes Act deals not just with organized crimes, they also deal with terrorism. That's a problem. So UAPA deals with terrorism, Central Act, Gujarat State Specific Act on organized crimes dealing with terrorism. Maharashtra, Karnataka, they only deal with organized crimes. They don't deal with terrorism. It's a huge problem because organized crimes are always different from terrorism. You may say that it is part of it, but that's easy. To bring terrorism also under an organized crimes is easy, but you have to differentiate that. Say, for example, terrorism is committed not for profit motives. They do that with an ideology. Organized crimes, looting people, stealing money, killing people, that's for money. It's a profit motive. And after terrorist attack, the first news that we all wait for is what? Who is taking responsibility for the terrorist attack? People will claim, organizations would claim, we are the ones who committed terrorist act. But organized crimes, people who commit crimes in groups, they don't claim responsibility. They don't want police attention. And they don't want media attention also. Terrorist attacks, they want media attention as well. So there are a lot of differences between organized crimes and terrorism. Why do we have organized crimes in the first place in BNS? That's a question. Like you said, it would give potential conflicts. Now, 113, terrorist act. Terrorist act is also, I'll just show that particular slide as well. Terrorist act is also mentioned under BNS. And what's the point in actually having terrorist act in BNS? You already have a central legislation, UAPA, that deals with terrorist act. Definitions being the same, offenses being the same. If at all there is confusion, yes, there is confusion. Do you know what the confusion is? If there is a particular person who is to be prosecuted under UAPA, there is something called a sanction for prosecution. Otherwise, you cannot prosecute that particular person. Here, if the particular BNS, not under UAP, according to BNSS would be sufficient, not under UAPA rules. Jurisdictional issues would be there. And one major thing with regard to UAP is it is very difficult to get bail. Very difficult to get bail. Stringent bail provisions. There are some judgments also, counterfeit Indian currency. If you deal with that, that's a punishable offense. BNS says only counterfeit Indian currency and not high quality counterfeit Indian currency. What do you mean by that? That's a challenge. So we have to wait for the Supreme Court judgments to kind of interpret this and then say whether these are the same or not. Now, interesting factor is offenses against the state, like terrorism. Now, terrorism has been brought under offenses against human body. It is not an offense against the state anymore. Earlier itself, there were confusion because waging war against the government of India and terrorist act under UAP itself was a challenge because Ajmal Kasab, Afsal Guru, all of them were penalized under waging war against the government. Section 121, death penalty was given, not for UAP terrorist act, though that was a part. Now there is more confusion because terrorist act under BNS, it is not an offense against the state. It is an offense only against the human body. Because you asked this particular question, ma'am, let me also kind of tell you that there is one more provision which talks about, I think my slides are skipping to the other ones. There's one more provision which is 152. So people rejoiced at one particular point of time because the erstwhile 124 is sedition. Everybody were booked under sedition. You speak against the government, you show visible signs against the government, you show visible representations against the government, you bring in some kind of a, some kind of a, not a rebellious act per se, some kind of a disharmony between the government and the people. Everything was booked under sedition. Kedarnath judgment were not followed. So they replaced sedition. Central government gave a warning, they replaced sedition. Now what do we have? We have much more problematic situation. We have treason right now. TREASN, we have SON, treason, not sedition, section 152. Look at the words that they have used: subversive activities, separatist activities. These are not clarified, these are not defined. Now, if you just look at these particular words, act endangering sovereignty, unity, integrity of India, right? You look at all these words. Now, this treason, right, under section 152 BNS corresponds to another provision under UAPA. UAPA section 2 clause O talks about unlawful activity. Certain parts and parcels of unlawful activity are reflected under section 152 of BNS. So is unlawful activity and 152 the same? There's a problem there Because if you look at the punishment under UAPA, for unlawful activity, it is only 7 years. But if you look at the punishment under BNS, it is not 7 years, it is life imprisonment. So there's so much and so much of problems, so much and so much of potential conflicts. Adding on to what you have said, ma'am, it would also be interesting to notice the fact that erstwhile IPC had provisions on weights and measures. There's one particular minor part chapter on weights and measures that was removed. Why? Because we have the Legal Metrology Act to deal with all that. Now the problem is BNS has also retained offenses relating to food adulteration. Don't we have another legislation for that? We also have provisions for sale of adulterated drugs. Don't we have another legislation for that? Bonded labor. We have separate legislations. Why do we have this? We have high court clarifications given earlier itself. At least we should have followed that. Look at the illustrations that's been given for certain provisions as such for criminal force, assault, and all that. If you look at the illustrations, whenever we are teaching that to our students, we still have certain things being there. People riding chariots, people firing cannons, people carrying other people on palanquins. Why do we have these things? Do we use chariots anymore? Do we fire cannons anymore? Do we have palanquins anymore? We don't have. So if 1860 IPC was of the colonial relic, colonial past, why do we have these illustrations now? That's a problem. So I hope I've kind of answered that particular question. Do I have the option to kind of focus on just one particular part and then in this particular session?
Yes,
Because I
sure,
do
sir.
consider that as
Go ahead.
important.
Before going to the, there
All
is a
right, all right.
question. I'll just, because it's related to the same topic, I'll just ask, because this is posted
Okay.
by Shubhi Shwani. So her
Okay.
question is that, what is the point of including the exact section 15 of UAPA in the section 113 of the BNS?
That is what that.
Same
Yes,
thing
thank you
that
so
the
much. So that's exactly, yes, that's exactly what I was trying to prove as well. So you not just section 15 of UAPA, you have section 15 of UAPA which defines what a terrorist act is and the punishment exactly being reproduced with one particular difference: high quality Indian currency, counterfeit currency being mentioned there. Here it is not high quality. That itself is a huge challenge. If you look at the additional provisions, say for example, using terrorist fund, right? Using property arrived obtained out of a terrorist act, harboring a terrorist offender, whoever unlawfully becomes a member of a terrorist association. It's so confusing if you look at the UAP. All these provisions are separate. 15, 16, 17, 18, 20. All these separate provisions in UAPA have been put under Section 113 of BNS as various subclauses forming part, various clauses forming part of the major provision itself. 113B, 113C, everything is a ditto reproduction. Problem is that it would be really confusing for the judges to proceed under BNS because UAP is a stringent legislation, almost on similar lines that of Tada and Pota, if we were to believe the Watali judgment. Bail is not a matter of right when it comes to UAP. Whereas in all the other cases in BNS, bail is a matter of right. BNSS and BNS. Bail is a matter of right. Only in exceptional cases that will be denied bail. You have bailable and non-bailable, correct? What do you mean by bailable? You'll get a bail. What do you mean by non-bailable? You still would get a bail, but that would be the discretion of the judges. Non-bailable doesn't mean you will not get a bail. Non-bailable means it is not your right. It is the judge's discretion to grant you bail. So bail is kind of a matter of right. But when it comes to UAPA, bail is not a matter of right. So if you are booked under BNS, much easier for you to get a bail. If you're booked under UAPA, you will not get a bail. It's very difficult to get a bail. Persons have languished in jails for more than 11 years because they were just booked under UAPA. So, so that's a problem. How do we solve this thing? What were the intentions as to why we brought all these things under this? That's a huge problem. Very recently, there was this one particular person by name Sai Baba who was a professor. He was physically challenged as well. There were so many issues with regard to him granted bail. That was precisely with regard to the fact that the sanction for prosecution was not obtained on time under the UAPA rules. In BNS, that sanction for prosecution under UAPA rules are not applicable. So, as good as saying that you do not require sanction for prosecuting any particular potential terrorist or possible potential terrorist. So, there is lots of confusion. So, we possibly have to kind of wait for any sort of a apex court interpretation to kind of give us that particular clarity. But thank you so much that you understood what I was trying to communicate, and I'm on the same. I'm with you on that. I'm on the same page. I'm on the same lines of thought as you were doing. If I've answered that completely or partially, I would want everybody to kind of understand this, and this being the worst part of or worst missed opportunity, I would say, so far as BNS. There's so many things that I skipped because of lack of time. See, when you talk about rape being an offense, so you have 375 and 376 earlier. Now you have section 63, 64 till 71. Now, see, 64 clause 2, okay, of BNS, which corresponded to, I think, 376. No, 64 clause 2, which corresponded to 376. 376 clause 2 specifically said rape by a person in authority. Say, for example, rape by a police officer, right? Rape by a medical practitioner over a patient, rape by a teacher over a student, rape by a nursing professional, or anybody for that. Somebody who is a jailer, somebody who has an authority. Rape by a person authority was punishable. 376, now it is 64 clause 2. It was punishable. When you read further provisions on rape, you'll see this particular provision. Can you see this particular provision? Can somebody confirm? Could you please confirm? Section 68, sexual intercourse by a
Yes, yes,
person in authority. Yes.
yes.
You see this provision, which is exactly the reproduction of 376 capital C of IPC. Now, I'll tell you the gist of this. What I was discussing was rape by a person authority, additional provision which doesn't use the term rape. It only uses the term sexual intercourse by a person authority. If you can see the highlighted part also, sexual intercourse not amounting to the offense of rape. There have been very infamous cases reported also. See, what is the difference between this provision, sexual intercourse by a person authority, and rape by a person authority? What is the difference? In the first one, there is no consent. In this one, there is consent. Correct? That is the difference. If there is consent, it will not become rape. If the woman has consented, it is not rape, but still it is punishable offense. Why is it punishable offense? Because of the position that the other person enjoyed. Employer employee fiduciary relationship, public servant, teacher student, doctor patient, superintendent or a manager of a jail, as well as the inmates of a jail. Because of the peculiar higher position that he enjoyed, the woman could not but give consent. Correct? She was forced to give consent. She never wanted a physical relationship in the first place. That is the reason why it is an offense. If both persons have voluntarily consented, there is no offense. She was forced to give consent because she was scared of the fact that some adverse consequences would happen to her. I will not get promotion, so maybe I'll do this. So, isn't this essentially vitiating consent? Isn't this essentially a consent obtained by coercion, by compulsion? I want everybody to read the definition of consent after this particular lecture, which is there in section 63 that defines what a rape is. Section 63 explanation gives the definition of consent. You know what the definition of consent is? An unequivocal voluntary agreement given by the woman. Unequivocal. There are no doubts. There are no confusion. They're unequivocal. I am saying yes. I am saying no. Unequivocal voluntary agreement given by the woman. Here is it unequivocal? Here it is a voluntary one. It is not. It is not. She has been forced. And still, there is a lesser punishment given. The court can tell the whole world that she consented to a physical relationship, though that particular consent was given because she was scared of the employer or the person authority. It is not rape because of the consent. It is just sexual intercourse. Are you justifying this particular provision? I am not. I am totally against this particular provision because this is equivalent to rape, because any vitiating consent should amount to rape. I think I'll conclude by just identifying one more provision. This is a new provision that was incorporated. What is that? Section 69. What is section 69? Somebody making a promise, and these are not gender neutral. These are not gender neutral. We'll discuss that possibly later, not now. Progressive, regressive, maybe. Somebody promising to you that he will marry you. Okay, so it's not gender neutral. He will marry you. Now, because of that particular promise, you enter into a physical relationship. Only because of that particular promise to marry, you enter into a sexual intercourse. And later, you understand the fact that it was a deceit. Later, you understand the fact that he was making a particular promise, which was a false promise. Okay? It could be very complicated to find evidences to prove that you subjected yourself to a physical relationship only based on that particular promise and nothing else. One step. There are several resources that are cited. What do you mean by a false promise? See, look at deceitful means. Deceitful means shall also include suppressing identity. So if I am the culprit and I am telling you, okay, I belong to a national law school, I get 3 lakhs of rupees per month, and you believe in that, and then we start to kind of go around, we start to have physical relationship. My salary is not even closer to 3 lakhs. It is not. It is nowhere close to 3 lakhs. Is that suppressing? Isn't that suppressing identity? Or if I tell you that I belong to a different caste, I belong to a higher caste, isn't that suppressing my identity? So if I tell you that I am not HIV negative, where in fact I'm HIV positive, hypothetically, then isn't that suppressing identity? So these all could be suppressing identity. It's not clarified. Secondly, much before BNS thought of this, our Supreme Court has said in 2 or more decisions that there are differences between a false promise and a breach of promise. What do you mean by a false promise? The moment I was promising that I will marry you, I knew that I'm not going to follow this. I'm going to cheat. I never wanted to marry you in the first place. What do you mean by breach of promise? With all good intentions, I promised that I'll marry you. But something unforeseen happened because of which I couldn't marry you. Can I be held responsible for that? The Supreme Court has said no. Now it's the interesting factor. Now you find out this particular judgment. There is, because it's very sensitive. It shouldn't be like me teaching you. There's one judgment given by the Supreme Court. Sorry, by the Karnataka High Court. Okay, by the Karnataka High Court before 2010. There's one judgment by the Karnataka High Court. Boy belonging to Brahmin community, girl belonging to an OBC community. Sorry for using this particular example because then it will be clear. You know what the court has said? There was a promise to marry. Eventually, there was the promise was not fulfilled. She filed the petition. You know what the Karnataka High Court said? The moment the girl knew that he was a Brahmin, she should have realized the fact that there is a lesser possibility for this particular marriage to happen. Isn't the court promoting caste discrimination there? Did you understand the problem? So if you belong to 2 different castes, it is not a false promise to marry, it's just a breach of promise to marry. That is what the situation is. And these harmful effects could also happen to, provisions like section 69 as well. There is so much to talk about. I think I'll just, possibly kind of end with just one particular note. And all of you may read these particular judgments also. At one particular point of time in the 1980s, we were only with Mathura rape. We were with Tukaram versus state of Maharashtra. So much and so much of confusions were there. We thought we progressed through several amendments, criminal amendments in the 1980s, criminal amendment in 2013. We're so progressive towards the rights of women. And still, even now, 2017, Delhi High Court as well as Supreme Court is a very infamous judgment. All of you might have watched the movie Pink, right? Amitabh Bachchan saying no means no. No, that is not the case in India, unfortunately. Mahmood Farooqi versus NCT of Delhi. Mahmood Farooqi is a theatre artist. He's a theatre director, very famous, still alive. Mahmood Farooqi versus NCT of Delhi. You should read that particular judgment. No doesn't mean no. Sometimes no. Sorry for saying this thing, but no sometimes may mean yes. That's what the court has said. Not going into the facts. If there are any doubts, I shall clarify. That is a problem. We haven't progressed. If I ask a very stupid question, do we have license to rape in India? Everybody might say no. We don't have license to rape. What a stupid question. See, the problem is when you read BNS, that should have been avoided actually. When you read BNS, if you are married, you in the sense woman, girl, if you are married and if you are 18 or above, you can't claim that your husband raped you, that your husband forced to have physical relationship with you. You can't, because there is nothing called as marital rape in India. Do you know why? Do you know why? Understand why. I mean, if there's something, everything that we say, see, this is old doctrine of coverture. See, basically meaning once you're married, you're alleged to have been consented, you're alleged to have given consent to the rest of the life for a physical relationship, which is a grave error. So marital rape could have been penalized, because most of the reasons that the people say is that if marital rape is punished, more and more husbands would be called before the court. So what? When POCSO was about to be enacted, there were different criticisms. Who is going to file a complaint against their own family member because kids are being molested, especially assaulted, especially within the family? Nobody will complain. You know what happened right now, right? Several cases on POCSO. Yet that will also happen in the case of murder rape. So anticipating a danger is not a reason for not having a progressive legislation. There is so much to talk about because rape on dead persons, not there. Rape on dead persons has not been agreed. Karnataka High Court another judgment 2023. If you murder the girl first and then rape her, then not even 377 would be applicable. Now you know what the situation is. I told you gender also includes the definition of transgender. What's the point? 377 as such has been removed. What do you mean by 377? First 12 377. Part of 377 had to be decriminalized. Homosexuality became decriminalized. What about the other parts? It was required. Now, unnatural sexual offenses as such is not there. Attacks on transgenders, where do they go? Do they go to section 63? No. They're ousted from section 63, third gender. So they wanted some progressive provisions. The BNS could have just retained those provisions. So there's a lot to say about disclosure of identity and all that, but that's going to be a bit too much. So I think I just possibly kind of wait for certain questions or possibly end this particular session as well. I'm so sorry that I had to kind of just go through a lot of provisions in one go.
No,
I'll stop sharing the slide as well.
So, sir,
Yeah,
do you
yeah.
think from the session, will it be wrong to say that BNS has filled in certain gaps for sure, but there are many gaps which needs to be filled because there are contradictory and there are conflicts between other statutes as well.
Absolutely. Yes, I think the time that we had between the first bill and the revision that happened, I think most of the universities did arrange workshops and conferences and all that exactly the way they're doing right now. And this is actually for understanding the changes. Earlier, it was basically kind of a critique. So I think the government would have been better that the government kind of realized those conference outcomes and then made appropriate changes because that was kind of a collaboration between academicians and actual practitioners and obviously judges as well. So that would have been more helpful in kind of solving certain defects that the BNS still carries on with.
So before going into the question and answer session, last question to you, sir, as an academician, how do you think we have to introduce this BNS to our students who have already studied IPC 1860? So how do you reach out to them?
Okay, there are a couple of ways actually, which will not be a foolproof formula because it's always a question as regards how can a fifth semester, sixth semester, seventh semester students, I mean all set of students, senior most students can still come back and then learn the changes being made. See, if you belong to a university, and I'm sure that the Anand Sagar has that particular feature in their curriculum, you should be offering a lot of elective courses, right? So and stream wise as well. So it's always good that you offer exactly like what the Anand Sagar is doing possibly. Other universities also may follow that, wherein you possibly kind of have specific courses, elective courses. You may be nominating or nomenclaturing that as pricing that as softcore courses, elective courses. In ours, it is elective courses. So have certain criminal law papers, wherein you would always fall back on BNS as a start to kind of reach that particular core part of the elective paper. That is always there. Secondly, universities, which Sayanand Sagar is doing right now, you can many of the other colleges as well as universities could possibly arrange conferences and workshops specifically on this new BNSs and the new Evidence Act, which is the Bharitya Sakshi Adhiniyam. So this could actually give an opportunity for the senior most students to kind of listen to those conferences and then to kind of gather the information that they kind of lost. So I think these are the things that universities can do. Possibly exactly the same thing that you're doing right now. Other universities may follow the steps.
Thank you, sir. We'll now move on to the question and answer session. I would request the participants to please post their questions. There are a few questions already, so I'll just read that out. So one question is by CB Chakravarti. So she posts that acts against sovereignty of nation is punishable by BNS. However, it is not specific, but it seems to be arbitrary. So what is the comment?
See, good question. Good question. See, because I'm also a professor teaching, counterterrorism and national security. It's one paper. There's so much to talk about that. So the fact that if it is not arbitrary, right? So you basically see it's there's a. I think I'll just sum that up with this one particular phrase. National security is essential for all of us, including the person who asked the question, to enjoy our liberty to the maximum extent. So it's there. Now, problem is because it's slightly arbitrary, the liberties that we sought to enjoy through our national security, we cannot enjoy that much of liberty as well. So our liberty gets curtailed because of national security provisions. Now, there is one particular case law. If you're not into law, you'll understand that later. One that particular Supreme Court judgment, just understand that much. Supreme Court judgment says, especially when it comes to criminal law statutes, we need to have clarity in the phrases that are used. A.K. Roy's case, clarity in the phrases that are used. But it is not always possible to actually have phrases with mathematical precision. Say, for example, sovereignty, security, friendly relations. It is not public order. It is not possible. It's very wide. So I'll at least go for a strict interpretation. Don't go for a too much of a liberal interpretation. Bring everybody into contempt. So go for a strict interpretation is what persons have said. What you said has a point, because just because of that particular provision, do you know the after effects? Possibly rightly guessed that there's the new legislation by name Telecommunications Act of 2023. There are provisions in the IT Act, Section 69. The person who asked this particular question may just refer to this particular provision, Section 69 and Section 69A of the Information Technology Act, wherein this, including this particular session that we're doing, if we are talking only about terrorism for the next 40 minutes or so, I am giving you the guarantee that the central government would be monitoring, intercepting, and decrypting this information. You may call this as an encrypted form of communication. Decryption formats is there. Look at Section 16 Information Technology Act. Interception, monitoring, decryption is allowed. 16A blocking access as well. So if the government thinks that you have done something that affects the sovereignty of the particular country, your equipments itself could be seized, and now you have electronic evidence as a primary evidence under Bharitya Sakshi Adhinayam as well. So that's a very relevant question. That's a very relevant point. However, we should not be arguing only against the government because we are enjoying national security, possibly only because of this arbitrary decisions taken by the government. Now you have courts coming to the rescue in certain cases. I'll give you one example, not too complicated, but if the government wants to brand one organization as a terrorist organization, do you know the procedure? Immediately after branding the organization as a terrorist organization, the government would, I think there's one in, not because Shivani ma'am is from Assam. I think there's one in ULF. There's one called as ULF, United Liberation Front. I think so. So that's a banned organization. That's a terrorist organization. Once the government brands something as a terrorist organization, the government, central government has to, and they are constituting a UAPA tribunal for assessing whether the terrorist or the organization that they have branded as a terrorist organization and banned is correct or not, whether their order is correct or not. So the UAPA tribunal has to vouch for the government's finding. So additional safeguards are also there. Implementation levels, there could be so much and so much of issues, because we see that a lot of the cases are possibly, some person might argue, I'm not naming them, that is actually for me to speak in another session regarding persons who have been possibly jailed under Bhima, Karagon violence and all those things. Maybe much easier. Got to wait and watch. What you said has a point. Absolutely has a point.
So there's another question, sir. It is said that there is a lot of conflict between, same provision between the BNS and the UAPA. So which law would prevail? Whether it's the BNS or whether it's the UAPA, which will apply to.
As of now, I can only say that to the extent of how the person and under what provisions that the person gets charged, that law will follow. I'll give you an example. Uh, it's not based on any particular political activity or something. Everybody is aware of the Delhi riots case. If you need the names, Asif Iqbal Tanha, Devangana Kalita, right? Natasha Narwal, all of them were jailed in Delhi without getting bail for over a year. So Delhi High Court had to actually come up with some kind of interpretations. I know what the interpretations are, but it's too much to kind of disclose. Interpretations to kind of grant them bail. You know what basically happened? They were only charged for the IPC offences and offences under Destruction of Public Property Act. Later, when it was too easy for them to get a bail, it is said that when it was too difficult to kind of, make them stay inside the prison itself, UAPA provisions were added. So if you want to refuse bail, you add UAPA provisions. So maybe there is a higher possibility that BNS would remain as it is. UAPA provisions would still be, used. And on top of it, you always have similar provisions existing in the BNS. Waging war against the government, that is always there. That's always there. So I reckon it is going to be the UAPA and not BNS offenses. We possibly might have to wait for the first person to be booked, and then we'll get to see. So conflict in terms of jurisdiction, who will take care of that particular matter, NIA or the local police or the ATS, anti-terrorism squad. Second one, whether sanctions are required under UAPA or not. Third one, stringent bail provisions. Which bail provision? UAPL bail provision, section 43D5, or the instance of Father Stan Swami, Gautam Navlaka, and all those persons. Whether that could happen, or whether liberal bail provisions under BNSS could actually happen. That problem is always there. Which one would be applicable? Got to wait and watch.
Okay. The last question before we end the question and answer session. So there's a question that why is BNS silent on marital rape?
BNS is not silent on marital rape. I think I confused all of you a bit. It allows marital rape. So if you look at the last part of section 23, which is almost equivalent to that of the last part of section 375 rape, it says there's an explanation. Sorry, there's an exception, and the exception says if you're married and then if you're 18, then you cannot any physical relations, any sexual intercourse by a husband on you or with you, that is not considered as the offense of rape, which means you're forbidden from complaining that particular act. Now, section 375, if you look at it, instead of 18, it was 50. But then there was a case law that increased that 15 to 80, independent thought versus Union of India. So now that has been borrowed. Now it is 18. Unfortunately, that is not 18, that is not 15, but 18. But still, marital rape, it is not considered to be an offense in India because of the way in which, unfortunately, we consider what a marriage is. You study that in family law, if you join, marriage is a communion of one man and one woman, so essentially giving all the rights to unfortunately to the man to be done. It was stuck in between. I'm sorry that my last words as for this lecture weren't heard. So I was trying to say that doctrine of coverture, meaning wives do not have any particular role after their marriage in terms of dealing with property or dealing with anything. It's the husbands that take a call. So that's a doctrine of coverture, COVERTUR, which is still in force in India. Unfortunately, the country that brought in this particular concept no more follows it, but we do.
Thank you, sir. Thank you. Like there is a lot of appreciation which is coming up in the chat box for you, sir. It was on behalf of all of them. I can say that the session was truly informative and substantive information for someone who's into the profession as well as someone who wants to be in the profession. So you have balanced it both ways, and we are grateful to have you with us today. So before ending the session, I would request Ms. Chetra to take over.
Thank you, Ms. Shivani. So I request Sir Manoj Kumar Jina to tell us about the DSU program.
Thank you, Chaitra, giving me an opportunity, and I'll thankful to Dr. Bharati and Dr. Sandeep and Miss Shivani, who has given the very informative session, and who has Dr. Sandeep has given more elaborately all the law information, which is encyclopedia of law. As I can say, Mr. Sandeep has the very vast information, and I hope those people who are attended today, who are the participant attended today, and they must be got the very fruitful information, and definitely it will helpful for their law career, and they know the more detail about the law career, and they can pursue, and they can be if have any kind of information they require, they can contact to Dr. Bharti and Dr. Sandeep, who are the expertise in this law profession, and they can give the more detailed information about that. And now I'm coming about Dayanand Sagar University. As Dr. Bharti also told, our founder Dayanand Sagar sir is himself is the barrister of this profession, and he's a law professional, and we our chairman and vice chairman also looking for Dayanand Sagar University. It is coming up in a better way in further law program, and it is a techno-based law program, and which is innovative interdisciplinary tech-enabled law program we are offering to the student. So which will be for three segment it is there. It is one for the BA LLB, which is the liberal studies with law program, law integrated program, which is 5 years program. and BBA LLB, which will be interdisciplinary. Again, it will be management studies with law integrated program, and it is 5 years program. And another is the after your graduation, the student who want to pursue the law program, it is a unitary law program, which is LLB, exclusively LLB program, which is 3 years program. So these three programs right now we are offering in Dayanand Sagar University. The students who are interested, the participant who are their relatives or their friends or anybody who are looking for the law career or law profession, so they can fill the application form by visiting the our website, or by visiting our, or they can call our counselor or our career advisor 08046461800. This is our contact detail, and they can visit our website www.dsu.edu.in, and they can fill the online application form to, or they can get the more information from our website also about this program. And we are also offering the scholarship to the student, either they can come through the CLAT exam or they can come through our DSAT exam. The Dayanand Sagar we are having the scholarship test also, which we are exclusively offering for the law students also. And these exams can be conducted online any part of India. The students who are wherever maybe they are sitting, they can get this information any part of India, wherever they are sitting. They can write this exam by sitting at home, and they can attend this exam. And this will be like, the scholarship will be offering by Dayanand Sagar University, approximately around 50,000 per year. If you talk about the entire program, around 2,50,000 they are going to get the scholarship if you, by completing your law program, for whether it is a BA LLB or BBA LLB. So, if the students are coming through CLAT exam, if the score is within 5,000 rank, they are also getting around 50,000 scholarship. So it depends on the their ranking. It is starting from the 15,000, 5,000 to 15,000 rank. In that only we are providing the students scholarship. And except that, we have the DSAT exam. The students who are not written the CLAT exam, or they have not got the get through the CLAT exam good rank, they can come through our DSAT exam. And through DSAT exam also they get the scholarship, and they can pursue these programs, the law programs. And except that also, that LLB, those students who are the already completed graduation, or they like to pursue the LLB program. And it is a 3 years program, and which will be very reasonable rate, and also techno-based program, where we have the the various facilities like moot court and technical, let's say, setup labs also there. And it is starting from the cyber security to AI ML integrated programs, AI integrated programs also we are having. So these are the things, if they want to know more detail, I like to invite all the students who are interested. They can visit our campus. They can meet Dr. Bharati and other professors. So to get the more detailed information, and they can meet our career advisor. So for detailed information about the law program, I'll be will it will be grateful, if you can, they can visit, they can personally see the setups. They can personally see the what kind of lab setups are there, what kind of moot court we have, and what kind of classroom facilities we have, what set of professors we have. So they can meet, and they can meet, and they can get the information. So I like to inform all the students. They the fill the this whatever the link we have shared. If we can fill these details information, so that we can share the certificate to you by online and by mail. And also you can get the detailed information about the program also, what kind of program we are offering, and more detail about the course curriculum and course syllabus and all. If you want, you can get it also through our professor. I'll thank you to all the participants who are listening very sincerely till the end of the program. And Dr. Sandeep's presentation was really excellent, and it is very, very informative. And those are particularly law career. They are already into the profession, or already planning to do this particular law profession or law career. So definitely it will helpful for them, and they can I hope they can get the very good idea and information about the career. Thank you very much to thank you and Dr. Bharti, who has given an opportunity to me, and also our CMO Mr. Deepak, who has given the opportunity to speak in front of all the audience. Thank you very much.
Thank you, Mr. Manoj. Thank you.
So, Dr. Sandeep has another meeting to attend. So, Dr. Sandeep would request, his leave from the meeting now, from the session. On behalf of School of Law, Dr. Sandeep, once again, we thank you for coming and, sharing your information. It was really informative. Thank you so much. We hope to meet you in next sessions as well.
Pleasure is all mine. Thanks a lot. Thank you so much. Thanks. Thanks.
Sandeep, thank you so much. Thank you.
Thanks a lot, ma'am. Thanks a lot, Bharati, madam, for
God
inviting
bless
me
you.
again.
See you
Thanks a lot.
soon.
Thank you.
Bye-bye.
Thank you,
Thank you.
Sandeep sir. Thank you.
Thanks a lot, Manu sir. Thanks so much. Thank you so much.
Over to you, Chetra.
Yeah, ma'am. Dear students, I was very happy to see and experience your enthusiasm and involvement during this webinar. I hope everyone have gained insightful and constructive information from our esteemed speakers. It has been such a honor to be a part of this wonderful webinar. On behalf of Dhananand Sagar University, I would like to extend my heartfelt gratitude to our panelist and esteemed speaker, Dr. Bharati S. Ms. Shivani Datta, and Dr. Sandeep Emman. Thank you for sharing your valuable insights and knowledge with us today.
Thank you, Chaitra.
Thank you. Thank you everyone for being here. Have a nice day.
Thank you.
Thank you.